In previous short lecture, we shall look into what are the ethics and environmental and why we need the ethics in environmental management. So for this subtopic, we shall look into the framework of ethical in the environmental protection. So it is becoming obvious that in the last decades, the environmentalism under all its form ranging or changing from conservation of ecosystem towards sustainable development, and it gains more and more influence upon our daily activities. So environmental organization appeared every day and they promoting all sorts of theories regarding the necessity in order for us to protect the environment in which we live. So it is also clear that not only was the public opinion receptive to these ideas, but there are political parties since environmental claims to be appeared in nearly of all current political agendas. That's why we have 5 principles in ethical framework. Number 1, the principle in environmental protection is the principle of private property. So it is extremely important to mention that the fact in order for us to solve any legal dispute regarding to the environmental aspect, one party must start from the distribution of property rights involved. So thus the statement A claims that B pollutes the environment must necessarily involve the following. A certain action undertaken by B has an effect, the invasion and also damaging the property of A. So in this case, it seems just that B must compensate A for the damages that has been mentioned, and also we can ask how a fundamental question. So is it possible in the above mentioned for a certain individual, for example like party C, to accuse B of polluting even though the action of B have not affected the party C's property in any way? So if we want to respect private property rights, so the answer would be no. So however, nearly all the environmental NGO who lobbying against the polluters, in nearly all the cases, do not have do not have property rights in the polluted areas. So for example, there would be the claim that made by the Greenpeace and also Agent Green, which the road is destroying the last forest landscape left intact in Europe, and therefore it must be stopped. So if we stick with this principle of private property, this claim actually has no substance because the environmental NGO do not have any property in the respective forest. So their claims are thus null and void. So this is closely related. You shall look into in Malaysia context. We all know that in Malaysia, development in Malaysia is dominated by the landscape of residential property. So kalau you tengok banyak high rise building. Therefore, Malaysia have formed a known as the Malaysian Green Building Councils, and then this council is actually discussing on the policy of sustainable development, as well as before they are making decision in allowing this residential property to be done. So they need to the contractor ataupun kita kata the big property company need to refer to the Malaysian Green Building Council first. So this is the first principle in the ethical framework, iaitu private property. Moving on, number 2 is the non-aggression principle. Kalau kita kata non-aggression ni, it is a situation whereby the policy of not attacking other parties. Itu kita kata the non-aggression principle. As we have stated above, this fundamental normative principle, so kalau you all boleh recall balik normativity principle, regarding the non-aggression is nothing more than a reformulation of the universal principle of private property. So the non-aggression principle can be briefly expressed in the following words. Okay. No action will be considered illicit or illegal. Thus, it is forbidden by the law unless it invades or physically aggresses against the person or property of another man. Quoted by the Rothbard 1997. So, pollutions falls into this definition. This is because it represents there is a clear physical aggression against the person or property of another man. Thus, the victim can press charges against the polluter. However, the so-called preventive legislation, which aim at preventing a future possibility of environmental damages. So, by itself, kita katakan itu merupakan satu aggressive action lah kan. Dia tak katakan non-aggressive. So, most of the actual environmental law will fall into this preventive category. Maksudnya apa? The policy of not attacking lah kan, not attacking other parties. So the following paragraph form the European directive that being extremely suggestive that in order on the one hand to prevent any impact, for example like packaging waste on the environment or to reduce such impact, thus providing a high level of environmental protection. Whereas the best means of preventing the creation of packaging waste is to reduce the overall volume of packaging. So this is clear that such a law institutionalizes aggressions as well as it hampers the economic progress. So kalau you nak tengok, you boleh tengok orang kata apa, perspektif in the global not global trend lah, but it is related to China's One Belt One Road initiative in the ASEAN regional. So how actually these ASEAN country members opposing this China's initiative known as OBO, One Belt One Road. So this is known as non-aggression principle. So moving on, the principle number 3 is the individual responsibility. So according to Van Mises 1951, he said that it can be best expressed in the words of only individual things, only individual acts. See? Thus, the principle of individual responsibility is nothing more than the application of the concept of methodology individualism in judicial matters. So, this could mean that the individual must be held responsible for his own action before the law. However, the above mentioned principle, although it is intuitively correct, it's totally ignored when it comes to pollution. Yelah, bila kita kata pollution ni, you tak boleh nak kira kan, oh yang keluar, yang buat apa tu pencemaran air ni siapa punya. Tak boleh. Benda tu you tak boleh nak orang kata apa, quantify. You tak boleh nak menentukan dia punya kuantiti, kepunyaan siapa, sebab benda tu memang orang kata apa, manusia, betul tak? Manusia tu ramai, you tak boleh nak detect mana satu siapa Ali. Oh, Ali dah buat pollute sebanyak berapa persen, apa tu, Rama dah buat pollution berapa persen. You tak boleh nak ukur benda tu. So the best example in this case, global warming and the depletion of the ozone according to Reisman 2002. So can a single individual through his everyday actions bring about global warming, or can he deplete the ozone layer? So it seems obvious that it is impossible for a single individual, regardless of his action, to produce this phenomenon. So the environmental theory advanced the idea that the actions of all human beings produce these climatic effects in the long run, and it is necessary for the state to adopt the legislation in order to control the air pollution. So however, to coercing the people to pay the huge taxes for preventing such phenomenon will take into account the fact that this individual action cannot cause global warming. So seems intuitively wrong. So maksudnya apa? There's no such thing. You can actually identify which individual caused the pollutions. Therefore, it is necessary for the government to actually to adopt the legislation in order to reduce the air pollution. Moving on. Next, this is the principle of proportionality. So, pursuant to the above mentioned principle, our short normative analysis concluded so that an individual is free to do anything as long as his actions do not resulting in the concrete or physical aggression against the person or property of other men. So, in case a person did carry on act of aggression against one person property, he should be held liable before the law for his own actions. So however, there is one important question arise. How should the aggressor make up for the damages he caused? So in order to answer this question, we can invoke the principle of restitution. So according to the proportionality principle, if a certain individual A damaged through pollution the property of B, so A is obliged to pay the B the value of the damages that he has caused. So the method of pressing charges in court will remain in the restitution principle, and the proportionality comes into picture while the environmental legislation does not. So although the legislation puts forward the correct idea that the polluters pay, maksudnya the polluter tadi tu compensate, we can go further and ask, who does the polluter pay? According to the principle of restitution, the polluter must repay the victim for the damages he caused. But according to almost every environmental law, the money taken from the polluters is automatically goes to the state budget, bukannya kepada individu yang orang kata apa tadi, yang menjadi mangsa lah, yang compensated tadi. So itu kita kata dengan the principle of proportionality. And last but not least, in the ethical framework, the last principle in environmental protection is the principle of strict causality connection. So according to this principle, the plaintiff must prove beyond reasonable doubt a strict causal connection between the actions of the defendant and also the invasion of his right. So this quoted from the Rothbard 1997. So again, sustainable development ni sebenarnya benda ni dah lama tau. Kalau ikutkan sejarah, dia bermula daripada tahun 1957 lagi. Tapi kita baru nampak kepentingan sustainable development tu sekarang. So moreover, the burden of proof will fall into the plaintiff tadi. So any defendant that being considered innocent until proven guilty. So we would apply this principle into the pollution case tadi. We have the process. A accused B of polluting. Okay, so if the pollution is visible, it will represent an aggression. So if the pollution is invisible, must prove that is invisible pollutions harms him physically in a negative way. So step number 2, must prove a strict causality from the actions of the B to his victimization. Maksudnya beyond reasonable doubt ni, yang you orang kata apa, yang you kena buktikan. Sebab you nak kena beyond reasonable doubt ni, contohnya macam dalam kes kalau you dengar hearing court, kalau orang tu dia accidentally orang kata apa, accidentally causing a death, kan, causing a death of a person due to his negligence. Tapi bila check balik, oh, due to his negligence tu datangnya bukan daripada dia, tapi daripada faktor luar. Maksudnya external factor, contohnya macam banjir kilat kan, banjir kilat, bawa kereta tak nampak, lepas tu dia terlanggar, contoh dia terlanggar anak anjing kepunyaan orang. Jadinya orang kata apa, pihak mahkamah perlu tentukan berlaku tak beyond reasonable doubt dekat situ. Adakah dia punya kecuaian dia tadi itu boleh orang kata apa, boleh indicate dia punya indicate tragedi kemalangan tersebut yang menyebabkan kematian anak anjing tadi. So step number 2, must prove a strict causality from the actions of the B to his victimization. So basically orang yang langgar anak anjing tadi tu dikatakan didapati tidak bersalah sampailah dia dibuktikan bersalah. So kena tunjuk sebab lah kan, kena bagi tahulah what are the kena proof kan the cause itself kan. Contohnya macam yang tadi hujan lebat, lepas tu check dengan kaji cuaca, ya betul hujan lebat, so benda tu adalah natural phenomenon. Other than that orang kata apa, is still beyond reasonable doubt lah. So although probably few people would oppose this basic jurisdictional principle, so environmental legislation ignores it in the most of the cases. So such an example, global warming. So the fact that pollution causes the global warming is far from being proven beyond reasonable doubt. Maksudnya tak tercapai di akal lah. So however, numerous law have been adopted to fix this so-called problem.